for having me. My name is Sean Young, and I'm the legal director of the ACLU of Georgia. Today, in the case of Masterpiece Cake Shop versus Colorado Civil Rights Commission, the Supreme Court ruled in favor of the Colorado baker who refused to bake a wedding cake for a gay couple and reversed the decision of the Colorado Civil Rights Commission. I would like to make 3 important points on this decision. First, the Supreme Court reversed the decision on exceedingly narrow procedural grounds that are unique to this case. Specifically, the Supreme Court reversed the decision because it believed that the Commission had exhibited anti-religious bias in some of the comments that it had made publicly when it ruled against the baker. Additionally, the Supreme Court emphasized that the baker's refusal occurred in 2012. That was the time when Colorado was not required to recognize same-sex marriages as it is required today. This court stated, quote, "Since the state itself did not allow those marriages to be performed in Colorado, there was some force to the argument that the baker was not unreasonable in deeming it lawful to decline to take an action that he understood to be an expression of support for their validity." It's a little long and legalese, but the point is clear, is that this decision occurred during a unique time in our history. And thanks to Obergefell v. Hodges, which legalized gay marriage throughout the nation in 2015, that circumstance will never be the situation again in the United States. The court also recognizes, and this is very important, the narrow impact of this decision. Quote, "The outcome of cases like this in other circumstances must await further elaboration in the courts, all in the context of recognizing that these disputes must be resolved with tolerance, without undue disrespect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in an open market." And that's a segue to my second point, which is especially important. In this decision, the Supreme Court repeatedly recognized that notwithstanding its ruling in favor of the baker, gay people must be treated with dignity in the marketplace. And I want to really emphasize that 8 justices signed on to the following statements that I am about to quote for you. And I really want these statements to really marinate in folks' minds. This is 8 justices of the Supreme Court saying these things today. Quote, "Any decision in favor of the baker has to be sufficiently constrained, lest all purveyors of goods and services who object to gay marriages for moral or religious reasons, in effect, be allowed to put up signs saying, quote, 'No goods or services will be sold if they will be used for gay marriages,' something that would impose a serious stigma on gay persons, something that many in this room can no doubt relate to." 8 justices went on to say, "Our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and in worth. For that reason, the laws and the Constitution can, and in some instances must, protect them in their exercise of civil rights. The exercise of their freedom on terms equal to others must be given great weight and respect by the courts." 8 justices signed on to the following statement. "While religious and philosophical objections are protected, it is a general rule that such protections do not allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services under a neutral and generally applicable public accommodations law." The court recognized that there may be a danger, that there may be a, quote, "long list of persons who provide goods and services for marriages and weddings who might be refused to do so for gay persons, thus resulting in a community-wide stigma inconsistent with the history and dynamics of civil rights laws that ensure equal access to goods, services, and public accommodations." And even in a separate opinion authored by Justice Gorsuch, who was appointed by President Trump to serve on the court, and in an opinion signed on by Justice Alito, Justice Gorsuch recognized that a vendor cannot escape a public accommodations law just because his religion frowns on it. Just let that sink in for a minute. The third point that I want to make is that the Supreme Court did not embrace the theory that businesses have a blank check under a twisted theory of the First Amendment to discriminate against gay people. Nowhere in the decision did the court even suggest that it would buy into that kind of unprecedented theory. But of course, in Georgia, unlike in Colorado, gay people remain unprotected under state laws. Of course, we don't even have a public accommodations law. And the ACLU of Georgia, along with other organizations, will keep making the case for equal treatment of LGBT people until equal opportunity is the norm and the law in the state of